Welcome to today's video. We're exploring a difficult and often misunderstood topic: whether non-citizen parents can legally live in the United States long-term to accompany their U.S. citizen minor child for school. We will clarify the legal framework, explain the well-known 21-year rule, outline why visitor visas are not a long-term solution, and share viable alternatives and strategies. We will also include a clear disclaimer, because this content is for general information only and not legal advice. Let's begin by reviewing the agenda. First, we will present the context and a disclaimer. Next, we will give the short, definitive answer and explain the visa gap. Then, we will explore realistic alternatives, examine a decision flowchart and a timeline to age 21, and provide an actionable plan. Finally, we will test your knowledge with a short quiz and wrap up with key takeaways and a summary. Disclaimer: this video is for educational purposes only and is not legal advice. U.S. immigration law is complex and changes frequently. Individual circumstances matter greatly. Always consult a qualified U.S. immigration attorney to receive advice tailored to your situation. Context: a family has a U.S. citizen minor who needs to attend school in the United States and requires ongoing parental support. The parents are not U.S. citizens and do not plan to work or immigrate permanently. The central question is whether the parents can obtain a long-term visa solely to accompany their U.S. citizen child for schooling. The short answer is no. There is no U.S. non-immigrant visa category that allows foreign parents to reside in the United States solely to live with and care for their U.S. citizen minor child. Under the 21-year rule, a U.S. citizen can sponsor parents for permanent residence only after the child turns 21. Additionally, B1 or B2 visitor visas are temporary and require non-immigrant intent. Attempting to use visitor visas for long-term residences through repeated trips or extensions is strongly discouraged and can lead to future visa denials or refusal of entry. Now, let's transition into why this gap exists. Now we examine the visa gap more closely. First, there is no derivative status available to parents of a U.S. citizen minor. Second, the 21-year rule is firm. A U.S. citizen can only petition for parents after reaching age 21. Third, U.S. policy separates a child's right to education and identity from parents' immigration eligibility. Finally, trying to live in the United States on a visitor visa, such as B1 or B2, conflicts with the non-immigrant intent requirement and is likely to result in future denials. Next, let's move on to workable alternatives. There are 4 principal alternatives. First, leverage U.S. family ties by having the child reside with U.S.-based relatives, if feasible. Second, pursue an independent investor visa, such as the E2 treaty investor, for nationals of treaty countries who can invest substantial capital in an active U.S. enterprise. This is independent of the child's citizenship. Third, consider specialized U.S. boarding schools that provide medical, psychological, or behavioral support. Fourth, utilize short-term support and delegation with U.S.-based caregivers or legal guardians, while parents visit on a truly temporary basis under visitor visas. Next, let's visualize how a decision might flow. This decision flow starts by asking whether the parents must reside in the U.S. long-term. If not, short, genuine visits on a visitor visa might suffice while local support is arranged. If long-term residence is required, the next question is whether U.S.-based relatives can host the child. If that is not possible, the family assesses eligibility for independent statuses, such as the E2 investor visa. If they are not eligible or willing, specialized boarding schools may be explored. If none of these options works, the family should reassess goals, timelines, and risks, rather than attempting to misuse visitor visas. Next, let's compare expectations with legal realities. On the left, we list common expectations: that a U.S. citizen child should enable parents to live in the United States, that visitor visas can be extended or reused indefinitely to cover multiple school years, and that special needs documentation might create a visa pathway. On the right, we present legal reality. There is no parental dependent visa based solely on a U.S. citizen minor. Visitor visas are temporary and require non-immigrant intent, making repeated long-term presence risky, and medical or educational needs do not themselves create a visa category. Let's now quantify and compare alternative options. This table summarizes 4 alternatives. U.S. relatives hosting the child can be cost-effective but requires careful planning and lawful guardianship arrangements. The E-2 investor visa requires treaty nationality and a substantial at-risk investment in an active business. It is independent of the child's status. Specialized boarding schools can provide structured support, though tuition and fees can be high. Short-term support and periodic parental visits may work for some families but is difficult for minors with intensive needs and must respect visitor visa rules. Next, let's outline a practical action plan. First, clarify your objectives, including the child's schooling requirements, the level of care needed, and your timeline. Next, audit the lawful immigration options available to the parents independent of the child. If relevant, assess E-2 investor feasibility by confirming treaty nationality, available capital, and the viability of a business plan. Consider whether U.S. relatives can host the child and whether specialized boarding schools are appropriate. If parents plan to visit, ensure visits are genuinely temporary and compliant. Maintain thorough documentation, including medical needs, educational justifications, and guardianship or caregiving arrangements. Finally, consult a qualified U.S. immigration attorney before making binding decisions. Now, let's visualize the long-term timeline up to age 21. This timeline depicts the period from the present until the U.S. citizen child turns 21. At present, the family assesses needs and lawful options. In the short term, they arrange local support through relatives, caregivers, or boarding. Over the first year, if pursuing an E-2 investor route, the parents plan and invest. If not, they stabilize support arrangements. During the school years, parents should maintain lawful temporary visits only, avoiding patterns that suggest long-term residence on a visitor visa. Around age 18, the family reassesses strategy. At age 21, the child can finally petition for parents as immediate relatives. Before age 21, the child cannot confer long-term residence to parents. This mind map organizes lawful paths. The central idea is lawful options, branching into hosting by U.S. relatives with appropriate guardianship and logistics, the E-2 investor route that requires treaty nationality and active investment, specialized boarding schools with admissions and support services, and short-term parental visits that must comply with visitor visa rules. It also highlights what is not recommended, such as using a visitor visa to effectively live in the United States, or filing repeated extensions. Finally, it underscores the importance of legal counsel for case assessment and risk management. Next, let's check your understanding with a short quiz. Quiz question. At what age can a U.S. citizen child sponsor their non-citizen parents for a green card? Options. A. Immediately if the child is a U.S. citizen. B. At age 18. C. At age 21. D. Never. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. At age 21. The 21-year rule is a key component of U.S. immigration law for family sponsorship of parents by a U.S. citizen child. Quiz question. Is repeatedly using a B1/B2 visitor visa to live in the U.S. with a school-aged child a viable long-term solution? Options. A. Yes if you leave every 6 months. B. Only if you have a doctor's letter. C. No. It violates non-immigrant intent and risks denials. D. Yes, if the child is a U.S. citizen. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. Visitor visas are intended for temporary visits. Attempting to live in the United States by repeatedly using a visitor visa violates the non-immigrant intent requirement and creates a high risk of denial or refusal of entry. Key points. There is no dedicated visa for parents to reside in the U.S. solely to accompany a U.S. citizen minor. The 21-year rule governs when a child can sponsor parents. Visitor visas are temporary and not a long-term solution. Alternatives include having U.S. relatives host the child, the E-2 investor route for eligible nationals, specialized boarding schools, or short-term support with compliant visits. Proactive planning, thorough documentation, and legal consultation are essential. This quick reference summarizes the essentials in a concise, markdown-style list. No parent-dependent visa exists for a U.S. citizen minor. The 21-year rule applies. Do not attempt to live long-term on a visitor visa. Consider E2 investment, relatives hosting, specialized boarding, and short-term support, and consult an immigration attorney for specific advice. Next, we will summarize the main points and close. In summary, U.S. immigration law separates a child's schooling needs from the parents' eligibility to reside long-term. A U.S. citizen minor cannot provide a long-term status to their parents before age 21. Temporary options must remain genuinely temporary. Families should plan using independent eligibility or third-party support structures. Engaging qualified counsel can help avoid costly mistakes. Finally, let's close with a thank you and a call to action. Thank you for watching. If this video helped you, please like, share, and subscribe. We would love to hear your questions and experiences in the comments. Your engagement helps us create more useful content.